Hello, everyone, and thanks for joining today's show, How to Avoid Discrimination on Job Applications. I think this is a really important topic, something that we commonly, I think, overlook. So much of the focus in payroll and human resources and benefits around compliance once someone is employed, the do's and don'ts, right? But it really starts much further upstream than that, in starting with the application itself. And there are some really, really clear do's and don'ts that have been put up by the EEOC and have been kind of known for a long time, but there's also some emerging trends in this area. So I think what we want to do today is kind of review what the EEOC guidelines are, but also talk about things that employers should be thinking about. And we're going to finish on 8 critical questions that you really need to avoid on any application. And have a great guest today. If you're a regular watcher of the show, you know Brian Chinker comes from the New York office of Jackson Lewis. This is what he does for a living. Brian, welcome back to the show. Really looking forward to today's conversation.
Thanks, Mike. Happy to be here again. Certainly an interesting topic today, and something, like you said, that's often not paid attention to, the onboarding and applicant aspect. There's so much focus on what to do during employment. So I think these will touch on issues that sometimes aren't being given too much consideration by employers.
Yeah, right. Okay, let's just start out kind of defining, if you could, what are protected class. Maybe we even back up to the EEOC. What is the EEOC? How long has it been around? And then specifically, what are the protected classes that we need to be thinking about here?
Sure. So the EEOC is the Equal Employment Opportunity Commission. It's the federal enforcement agency for discrimination laws, and they handle complaints regarding Title VII and other discrimination statutes. Of course, there's every state has some of their own laws and protected categories, but at the federal level, the Title VII, the ADA, the Americans with Disabilities Act, the ADEA, the Age Discrimination and Employment Act, those set the standard. And so the protected categories that we're looking at on the federal level are race and color, pregnancy, sex, which includes pregnancy, sexual orientation, and gender identity, as well as sexual harassment. You also have national origin and citizenship, religion and creed. And then, like I mentioned, under the ADEA, that prohibits discrimination against individuals who are older than 40. And the ADA, it makes it unlawful to discriminate based on a disability.
Can you maybe go a little more detail in? So we'll repeat something we say on a regular basis here. The purpose of this show is just to simply share the best HR compliance legal information we can with small and mid-sized businesses. This is not political. We don't lean left or right, but there's a couple of words that you put in there for protected classes that I carry a lot. There, kind of political lightning rods. What is it about being a protected class? So like race, pregnancy, those are really simple, kind of clear boundaries to understand, right? There's the emerging trends, obviously, around gender identity. How do things like that come into play when it comes to protected class?
Sure. So, we can start with the basic premise that, an employer can take actions against employees, whether it's a hiring decision, a promotion, a termination, for, any reason at all or no reason, right? Except there are certain protected categories that a decision cannot be based on someone's inclusion in one of those protected categories. So, for instance, race, right? If an employment policy or decision is, based on a racial classification, that's going to be something that's unlawful and can provide grounds for suit. So that's what we're really looking at. That these are areas that categories that shouldn't be considered in employment decisions. But there are a couple, for instance, pregnancy and disabilities, and also religion, where not only do those prohibit decisions based on those characteristics, but it also might require accommodations, reasonable accommodations to be given for people within those categories.
So to be clear, we're talking about hiring here. This is not the does the baker have to bake a cake for overused probably scenario on TV about your place of business, your beliefs. This has nothing to do with that. This is simply, are you hiring employees based on these specific criteria? So if the skills required to perform a job are X, Y, and Z, X, Y, and Z can't include anything on the list that you just rattled off. Is that a good way of thinking about it?
Yeah, that's right. And I think what you're getting at are really what we'd call maybe the basic principles of equal employment opportunity, right? That, applicants with equal qualifications and skills and abilities should be treated equally. And that an employer, should be able to provide a valid business-related reason for an adverse decision or, not hiring someone. And mainly that, employment decisions based on, stereotypes, those often lead to unlawful results. I think that's kind of the basics of what we're getting at, especially in the onboarding stage. Not so much the retaliation issues and such that might be in play, once someone's employed, but essentially, treating applicants as equal, regardless of these characteristics.
Yeah. So maybe an example would be, hopefully in most cases a decades ago example of, boy, this job requires lifting a lot of heavy boxes, stacking pallets. We can only hire men. Changing the requirement to you have to be able to lift over 100 pounds 100 times throughout an 8-hour day. Those kind of requirements, and it's not based on gender, right?
Right, exactly. You're looking to see if someone can fulfill the job duties, not, whether you're not looking for specific categories of people who can do that. Anyone who can, perform the job should be considered equally with others, who could perform it. Exactly.
So these categories, most of these, ADA, Title VII, wage discrimination, most of these federal laws go back decades, right? What if any emerging trends like around the Crown Act do you see? Maybe educate people at first what that is, but beyond just protected classes as people might think about them, what are some of the emerging trends?
Sure. Well, you mentioned one, the Crown Act, which was just recently passed by the U.S. House of Representatives, and that's going to the Senate. We'll see how it fares there. But the Crown Act is a measure that would protect employees from discrimination based on natural hairstyle and hairstyles that are associated with certain races or national origins. Right? These can be hairstyles like tightly coiled curls, or hair worn in locks, cornrows, twists, braids or afros. Those are the types of hairstyles they protect, which again are tied to certain races and national origins. So it would prevent employers from refusing to hire based on those that type of hairstyle. And that's something, we've seen, numerous, states look into that, or localities include similar discrimination prohibitions. And look, also, it's certainly important for employers to look at what their state covers as well, because there might be other protected categories. For instance, since I'm in New York, I can think of a couple that are not necessarily dealt with on the federal level that we have here, such as protections for domestic violence victims, or those with prior arrest or conviction records. So, like I said, these federal laws, Title VII, the ADA, they set the floor, but states will go above and beyond this, and I think we're starting to see that trend reach the federal level, with seeing the Crown Act get some attention and possibly get passed into law.
a lot of things you and I have talked about in the show in past weeks, Brian, is sometimes there's conflict between federal, state, local. Lots of HR legislation moving to the states that is duplicative, sometimes even local, that can occasionally conflict with federal law. This seems to be an area that is going that direction, but maybe not at the same pace as other type of HR legislation. Is that how you see that?
Right, I think so. And, things at the federal level obviously move much slower. I think the last change we really had before this Crown Act legislation was a few years ago, and this wasn't legislation. This was through the Supreme Court when the Supreme Court ruled in 2020 that Title VII's sex discrimination prohibition extended to sexual orientation and gender identity. And again, that followed lots of local and state laws that we saw, prohibiting discrimination based on those. So I think, as is, typical in a lot of, areas, once we see action at the local level, it trickles upstream, so to speak, to the federal level.
Right.
Where they start considering these measures.
Brian, I'm just thinking about if I'm a small business executive in a mid-sized company watching today, we're going to get to the list of 8 don't do's, right? What are some of the things we should think about we should do? I'm almost thinking about the inverse. So you identified for us the protected classes as identified in all those, Title VII, ADA, equal employment, all the federal legislation. And I suspect that's not a big surprise to people, but maybe the opportunity for most business owners is how should we be thinking about the job application? How should we be thinking about the interview process? And I'll even maybe move it upstream further than that to defining job requirements. Can you speak into that, how employers should think about before we even post the job, let alone take applicants, how you should be defining job requirements that really avoid any of these downstream issues, and candidly might not even require you to know what the protected classes are?
Sure, that's a great question, and I think one of the issues is that when we often think of discrimination, what comes to people's minds is the disparate treatment type of claim, where there's intentional discrimination against someone based on a category. And many employers understand that's wrong, that shouldn't be done. But what many employers don't understand, or just haven't seen, is that there's another type of claim, a disparate impact claim, where otherwise neutral policies that don't mention race or other protected categories can have an impact on those protected categories. So I think, right, it's important that when you're drafting job duties, when you're drafting policies for the company, that companies consider whether what they're doing could have impact on less applicants of certain protected categories applying or getting the position, or promotional opportunities. So it's not just enough to say, hey, we're not doing anything wrong. We don't consider race or sex or disability when we're making decisions. Companies should go a bit further and make sure that they're not potentially inadvertently doing something that has a disparate impact on people of a certain category.
Yeah, I mean, we did a webinar maybe 3-4 weeks ago where our guest, he was quadriplegic from the neck down from an accident when he was 19 years old, right? And so what a brilliant, inspiring young man. He's a new father now. Congratulations. And in our discussion, I'm like, man, what companies are so missing the boat by not tapping into a talent pool like him. But if you're if your interview process requires people to come to your office and you're not even easily accessible, or maybe it's posted on a website that is not easily accessible for certain people with disabilities. It's all these kind of things that we just don't even think about, right?
Right. There's certainly affirmative, proactive steps that companies can take to widen, the applicant pool to include, people, for instance, like you mentioned, with disabilities who might otherwise be excluded from the advertisements. I mean, I think at a minimum, right, advertisements should have an EEO statement saying that, that hiring decisions are not based on any of these, protected categories. But yeah, they can certainly go further and make sure you're advertising for positions in, that'll reach people of certain categories that might not otherwise be hired by your company. So yeah, there are certainly things that can be done there. In terms of disabilities, even in the hiring process and the interviewing process, there are steps that can and likely should be taken to accommodate people with disabilities. For instance, if we're talking about an interview process that involves a timed test or performing some physical activity that might be related to the job, it might be appropriate for a company if they, if there's something visible that makes it, very clear that this person may have a disability, to say, is there an accommodation we can provide for this test or for this activity? Is there any accommodation you would need? Again, we'll get into that a little bit later. You're not going to ask at that interview stage any information about what their disability is, the severity, or what it actually is. But it is okay to offer someone an accommodation even at the hiring stage, right? Someone who might not have use of one of their hands, or has limited factors there. If they need to write as part of the application, right, then the hiring individual can say, is there an accommodation I can provide that'll make this easier for you? So certainly, it's not just sitting back and making sure nothing is being done as to these protected categories. There's certainly an element of proactiveness that you can try to get people of these, make positions available to these people of certain categories that might not otherwise, view your ads or come in for an interview.
Right. I think the guidance we would probably give employers listening today is obviously ignorance of the law is no excuse, and we certainly don't condone any type of intentional discrimination. I think the safest way to avoid it, and there's so many other downstream benefits, is just to get really, really clear job descriptions and really think through what the actual skills required and behaviors that you want and need to perform the job. Because when you do that, it really sets up applications and interview processes that are completely, it helps you to avoid any of the EEOC protected class kind of issues we're talking about today, but it also totally sets up job performance, right? And communication and job reviews, performance reviews. If performance isn't what is expected to be, you're always mapping back to those skills and behaviors that you identified up front, and just avoiding any downstream misunderstandings, miscommunications. And any other guidance you'd want to give employers on what are the protected classes, what are the trends here before we talk about enforcement?
Well, I think just to pick up on what you last stated is that, having written policies, having written job descriptions, right, that's a start. And then what do you do from there? You apply those uniformly, right? You apply and enforce everything in an equal manner, and you show that by documentation. And, again, as I mentioned, even standards that appear neutral can be discriminatory if they have, an impact on certain protected categories. So that's always something to be aware of. But, simply, have policies that you apply consistently, and that's really getting you pretty far in compliance just by doing that.
Yeah. Okay. Brian, let's move on to the next topic here, and it's around enforcement. We've had prior conversations in the show about, if I've got an employee who is disgruntled, they think they should have been a non-exempt employee and therefore entitled to some overtime, and they report that to Department of Labor, and there's audits, and there's this whole legal process for that, right? What is the enforcement? So we know EEOC is the enforcement agency, but what does the enforcement process look like? How do these things usually surface? And then what are the potential consequences for employers if they get it wrong?
Sure. So at the federal level, right, the EEOC handles enforcement. So if someone is looking to bring a Title VII discrimination claim, right, that would be many of the categories we discussed above previously, race, sex, national origin, pregnancy, religion, creed. They're going to have to first file a complaint with the EEOC, and that'll be at whatever their local office is. And the EEOC will take that complaint, and they'll provide notice to the employer that there's been a complaint made and provide a copy of that. And typically what happens then is the employer is asked to provide a position statement and to respond to what the allegations of discrimination are. At that point, or sometimes even before that point, the EEOC might ask the parties if they're willing to discuss a settlement, and the EEOC can hold a settlement conference to resolve things. If things don't resolve early on at that stage, then there are likely two outcomes. One would be the employee or the employee's attorney would request what's called a right to sue letter. And that's a letter that the EEOC will issue, basically stating that the employee has a certain period of time to go file a federal complaint in federal court, with respect to those claims. Alternatively, when there's some very egregious conduct, or the discrimination claim hits on an area that the EEOC is really focusing on, the EEOC can decide to enforce it themselves, and the EEOC can conduct an investigation, and then if they feel it's appropriate, they can file a complaint in court and go after the employer. So sometimes we see settlements made with the EEOC. Sometimes it gets kicked out of the EEOC and goes the private route to court. And I should just mention that obviously there's a whole state and local network as well. Many states, if not all, have state divisions of human rights under that name or others, where state discrimination claims can be brought, either the same categories under Title VII and the ADA, or the others that are categories that might be specifically prohibited in that state. And same with localities. So for New York, for instance, we have the New York Division of Human Rights that accepts complaints, and we also have in New York City, for instance, the New York City Commission of Human Rights. And those can act similarly. They investigate claims, and again, claims can be brought in court, or they can be brought, within those agencies. So,
Brad, what do you see as the most common path? Do employees or prospective employees who feel that they've received prejudicial treatment, they've been discriminated against, do they normally go through their state enforcement agency or go right to the EEOC, or is it more common that they just simply contact a local attorney and this thing just goes right into a suit is being filed and either settled out of court or in court?
It really runs the gamut, because what I often see is even if an employee or applicant will hire an attorney, that attorney might still make a filing at the EEOC or the state division. One of the benefits that an employee gets in doing that is that once they make that filing with the federal or state agency, typically a response is required from the employer, in which we call it a position statement. The employer is responding to the allegations and providing the employer's side of what happened. And so the benefit to the employee and their attorney is that if they go to one of these agencies, they likely get to see the employer's side and the employer's position before they would go forward and make a court filing. So it's really a mix. What I can say is that, especially due to the pandemic slowing things down, that the EEOC or the state divisions may be a little bit slower in handling things, but again, in terms of filing a federal Title VII claim, it's a prerequisite to go to the EEOC. So some employees might choose to just file under their state or local laws so that they can get to court right away, instead of filing with the EEOC and waiting to get that right to sue letter.
Yeah, and I certainly haven't seen probably a fraction of these compared to you. This is what you do for a living, but my experience is more common than not. It's the employee who feels discriminated against. It's their attorney who is performing these actions on their behalf. So, and I think maybe the reason I even bring that up is one of the things I think we face in I'll call the umbrella of HR, especially in small and mid-sized companies that don't have big HR staffs filled with SHRM certified HR professionals. There's this, oh, I know my staff, this will never happen to me, kind of thing. And just assuming, oh, so-and-so is never going to go, none of my employees would ever go to the EEOC, they wouldn't even know how to do that. Well, they don't have to know how. All they have to do is pick up the phone and Google lawyer near me, and whether you're right or whether you're wrong, whether you are discriminating, whether you're not discriminating, doesn't matter if the employee has a case or not have a case. You are now in a position with a cost and effort to defend. Am I saying that right?
I think so, and I think probably what stems from what you're saying is that really companies should try the best they can to resolve these types of issues internally, and that's why I think it's so important to have a reporting system for internal complaints that actually works, right? One that's actually going to conduct an investigation and involve the employee, let them know their complaint is being taken seriously. If that's a culture and a policy, a written policy, that's established by a company, then they can often find out about these complaints and take appropriate action beforehand, before it gets out of control and becomes an actual legal claim filed with the EEOC. So I think that's really important to do, and oftentimes in litigation it comes out how the employee found their attorney or why they went to them. And sometimes it's because no one at the company was listening. Other times it's as simple as there was a small issue. Maybe it was just an issue of on a paycheck of a couple $100s that the company didn't have a procedure to deal with, or they just ignored. And then that employee goes to an attorney, and what do they know? Not only is it a $200 issue, but there's a discrimination claim, there's an overtime claim, and something that the company could have resolved internally for a very small amount now becomes a full-blown litigation with additional claims. So having a reporting mechanism, which I often advise companies to have multiple people that discrimination complaints can be made to, so that if that one person is involved in the discrimination, there's someone else they can go to. Some companies have hotlines. Again, this might not be so applicable to applicants because they're not getting that information yet, but it's certainly something as it relates to the filing of EEO complaints that companies should consider.
Yeah, we're definitely wading into waters of when someone is employed, but I think it does speak to the further upstream you can address the problem, the better, right? Start with great job descriptions that lead to great applications, that lead to great interview questions, and don't get you in this trouble downstream. So the best way to solve a problem is to create a process that the problem never existed in the first place, right? Anything else you'd want to say on enforcement? I don't want to unnaturally scare employers here, but what kind of money would someone be looking at just as a simple cost to defend a case? What kind of money would we be looking at in penalties from the EOC for a violation?
Right. So in terms of the cost to defend a case, that can be, range from a very small amount if, upon receiving a complaint, the company looks into resolving it right away and does so. Obviously, there's the amount that they resolve it for. But, if a company is going to fight these claims and litigate them, then they need to consider that, they are going to pay both their attorneys, and if they lose, if the employee prevails under these statutes, they're entitled to their own attorney's fees. So that's something where, the longer a company fights, the more potential there is for a large sum being owed. Talking about large sums, I think was it about a year ago that the EEOC had its largest settlement ever, I believe, of about 20,500,000 about. And this was a company that just had real systemic issues with respect to race, discrimination against African American employees, and sexual harassment. The investigation showed that basically, African American employees were not being promoted equal to others, and that even when they were, or in whatever positions they were in, they were being paid less than other non-African American employees, and that there was also rampant sexual harassment. And further, just as a kicker, right, they retaliated against those who had complained. So there are large ones, and again, not to scare anyone, but that's the very high end. But as we discuss, what damages are available, there certainly are a variety of different issues, right? Even if an employee doesn't get, if an applicant's discriminated against, and they end up finding a new position somewhere else within weeks, right? Their economic damages might not be that much because they've found replacement employment, but depending on what occurred, they could have compensatory damages, or as they're more commonly known, emotional distress damages of a significant amount. Here in New York, there are two types of emotional distress damages, and some courts throughout the country do it look at it this way, and some look at it a little differently. But here it's split into two categories. There's garden variety, emotional distress, which is where an employee just can basically say, I've suffered discriminatory conduct, and therefore I've suffered humiliation, embarrassment, anguish, sleeplessness. That doesn't require anything in terms of medical documentation, and those awards can be as high as $125,000 for that type of emotional distress. And then if the employee can actually show that they sought medical treatment, right, maybe for depression, or if there were actually physical manifestations of this stress that was caused by discrimination, they can obtain an emotional distress award going far beyond that 125. So there are damages here that look, frankly, they should to some extent scare employers, because those are amounts that no company wants to pay out of their hard-earned revenue that that has been earned. So that's why it's so important to comply with the law and do what's required to treat people equally, so that there isn't this type of exposure down the line.
Yeah, and there's this twisted reality that it's the smallest companies that have the least resources that would have the most devastating impact, because that you're giving an example of one employee filing suit in what the damages might be. If you're a 50-person company or a 100-person company, maybe you can absorb that. If you're a 5-person company and you're working on razor thin margins trying to survive and build a business, I mean, one case could close the doors, right? So the risk is real, and ironically, it's most real probably for those least equipped to deal with it. Thus, the reason for conversations just like the one we're having right now to educate, make sure we're addressing these issues as far upstream as possible.
Exactly, and fortunately for smaller employers, under Title VII, there are caps on the amount of emotional distress and punitive damages. However, for employers under 100, that could be $50,000. Those between 101 and 200, 100,000. So there's escalating provisions, but that's not necessarily contained in similar state and local laws.
Right. Okay. Let's go on to some of the concrete notes. I'm looking at the clock here. I think this is really actionable for folks. So we've kind of identified 8 critical questions to avoid asking, and it says on the job application, but it goes for the interview process as well, right?
Sure.
Brian, I'm just going to hand the reins to you. Why don't you just take us through the 8?
Sure. So I think the first one we'll discuss is our questions about previous convictions. These are so-called, ban the box laws that prohibit companies from asking the candidates about arrest or conviction records at certain points in the application process. So, for instance, in Washington State, there's a law that prohibits advertisements that state they exclude, felons, or state no criminal background, right? Because those might dissuade people with criminal backgrounds from applying. That law also prohibits questions about a criminal background, either verbally or in writing, until the companies determine that the applicant is qualified for the position. There are other laws, like in California and New York City, that go even farther and don't allow any inquiry into a criminal conviction until after a conditional offer of employment has been made. And so, therefore, what these laws would say, you can't put any question on the application or, obtain information about criminal conviction. Now, it's important to know what your jurisdiction may require, because, some of these laws may permit a company from looking into public sources, right? Criminal dockets, can be publicly available. So some may allow an employer to do that. But for instance, I know that I believe California and New York City don't allow the employer to even, look into those areas. And I can tell you from experience, there are, individuals out there who are just trolling the job boards in these jurisdictions, and they will find advertisements that say something improper about, clean record or something like that. They won't even apply, and then they will file a complaint with, a state or local, division of human rights. And I've had a number of those, and it's difficult, right? Because that is a violation of the law. And so, there are people, who are out there trying to, enforce these even outside of, the government agencies that do so.
Brian, so it seems, self-evident why someone would want to ask that question. You want employees who are good, honest souls, stand-up citizens, right? What if you can't ask that question? What questions should they be asking to try to mine for those values in those competencies and skills?
Right. Great question. And, really the company should be asking, job related questions, right, about the skills and qualifications. And understandably, a criminal background, a criminal conviction, can be a concern. And so, these laws are not saying that you cannot look at that at any time. It's just, at a point, typically once you've determine that that applicant is qualified or will be offered the job. But even then, some of the laws even go so far as to require a certain analysis to be done. That for instance, if you're hiring a truck driver who's not going to have handle any cash or any money for the business, and that they have some conviction for some financial, crime. Is that something that would disqualify that applicant for that job? Likely not. It's not job related. What concern really is there based on that? And so, there are laws that require companies to go through a step-by-step analysis to determine things like, how long ago was the conviction? Is there any record of rehabilitation or good behavior since then? How old was the individual at the time of the offense? Does the offense bear on any of the duties of this job? So my recommendation still to employers would be, even if you get to the stage where you are conducting that criminal background check and something comes up, that shouldn't just, companies just shouldn't have a blanket policy that a conviction disqualifies that applicant from a job. They should look into those factors to determine if it's actually relevant to what this employee will be doing.
All right, that's good guidance. I'm going to move us along. Let's take the next one. Talking about salary history. This is an interesting one for me.
Sure. So, salary history and, bans on asking employees about their salary history are, really go under the rationale of, if there was, prior discrimination against this applicant that artificially lowered their salary because, for instance, it's their sex or their race or what have you, that relying on that past salary history only perpetuates the discrimination that's been suffered. So there are a number of states and jurisdictions that ban salary history inquiries. And so really what I suggest to employers, even in jurisdictions where they don't have one of these laws, is that they still don't look into salary history. I think a best practice is to really have a company that you set your own pay scales for each position. So obviously the first part is understand your state and local laws in this area. And even if one doesn't apply, understand common provisions, right? Some prohibit inquiries into the salary history. Others prohibit the inquiry and then use of the salary history. And some of them have provisions where even if the applicant voluntarily provides you that information, you still can't consider it, which obviously is a hard one to prove you're not considering it. But that's why I think there is a need to have a documented pay scale for each position, right? That should probably go hand in hand with the job description. And that's not to say everyone who gets hired gets paid the same exact rate, but that the company should consider legitimate factors such as years of experience or other, or level of education, right? If someone has a higher degree, that might be a reason to pay someone more. But those are the more legitimate type of factors to look at, rather than something so arbitrary as what they were earning in their prior position.
Yeah.
And so this is one where I think managers really need to be trained on this, because even if you're not asking for this on an application, it's something that can easily come up during an interview. And I think that certainly removing it from the application, right? Train those interviewers not to ask about it. Those are simple things, and again, I think those are best practices, along with having that pay scale for each position, that would really avoid the need to even ask for someone's salary history.
Yeah.
And that is to say, you can ask, what would you like to make, right? That's not a prohibited question, and that's probably a better one, right? What's the minimum salary you're looking for? What's the range you're looking for?
Right.
Those are probably better questions to ask.
Right. And if you're, I can think of two reasons that you'd want to ask, right? Number one is you're trying to size what it is that you would need to pay this person should you hire them, right? So that's a legitimate question. There's also another avenue of you're wanting to test, are they a high performer? Are they a high performing employee in their current role? And if you're making X, that's validation of that. So but you can't ask the question, how much do you make? You got to find other ways to ask it, right? Find ways for them to demonstrate that they are a high performer, whether it's a salesperson's stack rankings or someone's asking about what feedback they got from their boss in their last job review, other ways to explore their current job performance. Any other guidance you'd give there, Brian?
No, I think that's right. There are likely other factors you can look at. And again, look, if an employer is in a jurisdiction that doesn't prohibit this, that's fine. They can ask these, but these questions about salary history. But I think employers should be cognizant that there is a reason for these prohibitions, and that even unintentionally, that employer could very well be continuing a discriminatory act of a prior employer in keeping someone's salary low. So that might be reason enough for employers not to want to get into that, even though there might be a business reason, as you suggested.
Yeah. All right, prior convictions and salary history are probably two of the hottest lightning rod topics of the 8. I'm gonna let you accelerate through the remaining 6. Tell us about age.
Sure. So age is typically not something we want to find out about at the hiring stage, right? It's not necessarily unlawful to ask someone how old they are, or their birth date, or year of graduation, right? All of those even if you're not asking for the age, can give you a sense of someone's age. But certainly knowing someone's age can lead to a decision that's made for unlawful reasons that violate the ADEA or local law. So it can really cast doubt on what that information is being used for, because really unless there's a bona fide reason for knowing someone's age, right? So for instance, on some job applications, right, we're gonna have, are you over the 18 years of age, right? That's something that in many jurisdictions is important, because 18 or 21, there's certain laws concerning hours and certain things that must be done for minors. So that type of information might be fine, but there's no need for that date of birth. And going back to what we just discussed, a criminal background check. I know employers will say, but I need to get a date of birth typically to run that background check, and that's absolutely true. And so, a suggestion there would be, number one, make that criminal background check authorization separate from the employment application, right? Make it clear that it's that information is being sought for something unrelated. Additionally, as might be required in some jurisdictions and others not, the running the criminal background check later in the hiring process can avoid these issues too, right? So if the company has determined that someone's a qualified applicant, and then they're running this criminal background check and getting the date of birth, that's different than asking it for that date of birth on the criminal background authorization up front for every applicant, even for some that you might not end up running a background check for.
So even if it's unintentional, you could be, by having date of birth on an application, you could be signaling that, hey, I only want younger people, or I only want older people. Even if that's not true, you're really just setting yourself up, especially for these people you're talking about, Brian, who are trolling, looking to be opportunistic and sue you and get an out of court settlement for just ultimately making a stupid mistake, right?
Absolutely. I wholeheartedly agree. And, I think this even goes beyond things that are on the application. I have many clients who have come to me where, they've conducted an interview, gone through the application process, and then, someone as part of the hiring team looked up the applicant on social media, right? They did a Google search, or they went on Facebook, or, looked to Twitter to see posts. And the problem there is that you often learn things that you shouldn't know, right? So even if you haven't asked for age, now you've looked at their Facebook, and maybe you just saw a 60th birthday party photo. Now you've learned their age. Maybe you've seen that found out information about their sexual orientation, and those are things, while at the outset might be the applicant might not be aware of, but those are things where they can, if that came out in a subsequent litigation, or at any time, those are things that can cast doubt onto whether the employer was actually using legitimate job-related factors in making their hiring decision, rather than relying on those other types of things that might fall under protected categories that they might have found scrolling through a Google search or on Facebook.
Right. All right, I am looking at the clock here. I keep breaking my promise. We're going to accelerate. So we talked conviction history, salary history, age. Let's real quickly: citizenship, pregnancy, religion, alcohol, tobacco usage, and what else do we have here?
Sure.
Disabilities. I think we already kind of hit on disabilities, but
yep. Sure. So I'll fly through citizenship here. So again, this is someone's citizenship status is something that should never be asked about on an application, or even verbally, right? The only question that should ever be asked, and again, I would recommend this is in writing, because verbally things can be spoken in the wrong way, but they should be asked whether they're authorized to work in the United States, and that's all that needs to be asked, because the issue is going to be, if they are hired, they're going to have to fill out the form I-9, which will establish their identity and their authorization to work in the United States. And so there's no need to go beyond that, right? There's no need to find out if someone's a citizen, because that's not what's required to work in the US to be a citizen. You can have various types of authorization to work for non-citizens. So any type of pre-screening, even if you're getting into the I-9 issues, right? There's no reason that the I-9 information should ever be requested before a job offer is made. That will often be viewed as discriminatory based on citizenship or immigration status.
Yeah, and our guidance here to employers, I mean, the fact that people put it on doesn't mean you're some xenophobe who is intentionally trying to filter out non-US citizens. You probably just legitimately think, hey, they got to be able to work here legally. Just frame the question that way. Are you authorized to work legally? Because they can have a student visa, they can have a green card, they can be a spouse. There's a whole bunch of really good legal reasons why great talent is authorized to work, but they're not a U.S. citizen. So, all right, religious holidays.
Sure, sure. So religious holidays, that's one where, questions that get into an applicant's, religious beliefs can be problematic. For instance, you're getting it, if you're asking specific days, that the person can work, and then, basing an employment decision based on that, that can be discriminatory because, religious accommodations are often required. So, if someone, for instance, can't work on, Friday nights or Saturdays, that's something that might require an employer to provide an accommodation for, and isn't necessarily grounds for a termination. So, there are exemptions for certain religious organizations on this, but unless you fall within one of those, this is probably something to stay away from. Certainly asking about religious holidays and even asking about specific days they can work can then lead to these types of issues as well.
Yeah, and I think in the context of an application, this is the kind of thing you got to work out maybe downstream, right? I mean, if this person says I can't work on Sundays, but they're applying to be an NFL referee, the job is on Sundays, right? It doesn't mean you have to hire people who can't work on and give unreasonable accommodations. This is simply the application process. I think you're just putting a target on your back by, you are implying a bunch of bad things about your hiring practices, whether they're true or not, by simply asking this question. Is that a fair way to think about it, Brian?
Exactly. And a lot of this is appearances, right? Even if you're asking something that's not, unlawful to ask about, if it's something that raises an issue, for someone and then they don't get the job, they very well might assume that that's why they were not given the job. Then you're in the position of having to defend your hiring process. So it's better to just, leave those things out.
All right, I skipped over pregnancy. Talk about pregnancy, children, marital status.
Sure, sure. So, pregnancy, really, hiring managers, this is often where it comes up because pretty much, no job application should be asking about, pregnancy or children. But oftentimes, hiring managers are, you're having a conversation with someone and, topics come up, but these are ones that you really want to avoid. I think that along with pregnancy, right, whether you have children, even a simple question, asking a woman, do you prefer to be called Mrs. or Miss? Right now you're trying to get the implication of whether she's married or not, and that could be used to discriminate against someone based on familial status. So you really want to avoid those questions, and look, questions that you're going to ask of women should be the same questions you ask of men. So you shouldn't be asking women if they're pregnant, right? Because you're not asking men those same questions. And so, I know that I have one example of an EEOC complaint where, an offer was made to an entry-level woman. She called back to accept it. And on that acceptance call, she said, I just also wanted to inquire about your maternity benefits. Half an hour later, they called her back and rescinded the job offer.
No.
What happened next? $100,000 EEOC settlement with all sorts of injunctive relief requiring training at the employer's cost, all sorts of policies having to be distributed. So that's something a bit blatant. But again, those types of questions, just that there's no reason to get into it because there's no legitimate reason that you'd use that information, right? Whether someone's married or pregnant or has children, there's no reason you need that in the hiring process.
Right. We keep repeating it, but it goes back to have a great job description and then have your applications and your interview process mining for only those skills and behaviors required to perform the job, right?
Exactly.
All right, alcohol and tobacco usage. This is one maybe people don't think about.
Yeah, this is interesting, and really, just to start off, companies should look into their jurisdiction because some states will allow ban, allow a company not to hire someone based on, nicotine usage. For instance, there's states, Washington, Texas, Pennsylvania, Massachusetts, to name a few, where, you can ask applicants about that type of usage. And, again, look, it's a laudable goal to, want a healthier workforce, that can have impacts on, insurance rates. But there are also many other states, more than half of the states, that protect employees from adverse employment actions based on their off-duty activities. So again, no one's saying that a company, cannot prohibit employees from, smoking or vaping on premises. The issue is asking an applicant if they smoke, and that, for instance, New York, California, many other states, will ban these types of questions, either banning them specifically as to nicotine usage or just generally as to off-duty activities. And again, getting into the alcohol usage, that's problematic because, alcoholism can be a disability under the ADA. And if you're asking at the pre-offer stage about, their use of alcohol, you're really opening up that line of questioning and, disclosure of information about, someone's frequency and, quantity of alcohol intake can lead to a potential, disability discrimination claim.
Yeah, and if you're trying to mine for, will this person show up to work and be productive, exclude it from the application, but develop mature interview questions that you properly mine for those skills and those behaviors that you are able to find out whether they do show up on time, whether they do come to work, whether they are productive, without having to extrapolate some, extrapolate probably relatively inaccurately what their job performance would be based on the use of a substance, right?
Exactly. Right. And so you can ask them if they've gotten in trouble previously for violating an employer's, policies. But you want to stay away likely from these direct questions, especially if you're in, one of the 29 states that would, find it unlawful.
All right, number 8, disabilities. This is kind of a softball here.
Yeah. So this is one where, employers are generally prohibited from asking questions about disabilities before making a job offer. As I mentioned earlier, if during the interview process, the employer reasonably believes that there's an accommodation that's needed as part of that interview process, then, that can be offered. But, as part of the interview process, like in the instance of taking a test or, lifting up and carrying something heavy or, reaching up high, those can be offered if it's obvious to the employer that an accommodation might be needed. But again, the employer is not asking about the actual disability. And so, right, we're never asking about the nature or severity of that pre-offer. And so, again, even if there, if we're just sitting there having a conversation and, no accommodation would be needed for that, then this topic should really be off limits. And, let's remember, the onus is generally on the employee or the applicant to request a reasonable accommodation, right? Then we get into that interactive process, which, by the way, should be documented. But typically, we're looking at the employee to, give a disclosure of information that would lead us to, offer an accommodation. But that really, by and large, should not be addressed at the pre-hiring stage.
Yeah, and I guess deviate just slightly, but in the current climate of unemployment and job participation rates, and maybe not everybody listening today is deep in the war for talent, but a huge percentage of us are. When it just in my hometown, almost every single restaurant has diminished hours because they can't find staff, right? The war for talent is no longer some a large enterprise thinkery topic. This has come to Main Street. And so when you're searching for talent, you have to think about making accommodations to tap into larger talent pools, right? So beyond just omitting this from a job application, I would encourage everybody to really think about, do I really have to have people come into an office? Can I be more virtual? What if I made certain accommodations to the way some jobs are performed, including access to my building and office, in the tools that I supply? Does that open up new avenues of talent pools that I can tap into? So I think following the law and doing the right thing here to avoid any legal consequence also coincidentally maps perfectly to a great modern talent strategy. So Brian, as always, really enjoy our conversations. An hour goes by super fast with you, and I get smarter every time I talk to you. Can you maybe just spend 20 seconds telling everybody about Jackson Lewis and what it is that you guys do?
Sure. So I'm an employment attorney at Jackson Lewis. We're a nationwide law firm with over 60 offices throughout the U.S. We focus exclusively on labor and employment law and representing employers in all aspects of the employer-employee relationship.
And I would say that Assure relies on Jackson Lewis. Certainly, we provide our own frontline HR services. But when we have the real hairy issues, we rely on Jackson Lewis as our call it tier 3 support to answer the tough questions. And they're also a supplier of compliance content. So if you check out assuresoftware.com/blog, you'll see a bunch of compliance content where they're helping us inform you of all of the changes in HR legislation that are impacting small and mid-sized businesses. So to keep up on the latest information, I would encourage you to tap into that resource. Everything we talked through today, it's the twisted irony here is the companies that have the least resources to deal with these issues are the ones that are most vulnerable, right? These are small, mid-sized, growing companies. Big companies, they have big HR staffs of SHRM certified professionals. It's the smaller companies that they don't know what they don't know, and hiring a $75,000 or $85,000 a year dedicated HR person just isn't feasible for them, and that's where we come in. So we have 3 different levels of HR support where we can be your responsive call center support for just your managers at an absolute fraction of the cost of hiring a full-time HR staff. We can be proactive with your managers, helping do more than just simply write employee handbooks, but job descriptions and leaning into a talent strategy, or we can be the complete HR department for you. One of the things Brian was talking about earlier was employees self-reporting what they believe to be EOC discrimination violations. One of the reasons why so many companies come to us for HR is that an employee might not feel comfortable, even if they have internal HR staff, because they know that their boss has a pretty close personal relationship with the HR manager. They just might not feel that they're going to get the level of confidentiality they need. When you survey employees, it's pretty clear they prefer to have a third party outsourced HR resources that they can go to because they believe it's an unbiased opinion. So whether you want us to be your complete HR function, fractional, or partner with your own staff, we have a model that can work for you. So with that, thanks everyone for joining today. Brian, thanks for joining me again. Really enjoyed the conversation.
As always, Mike, thank you. I appreciate it. Happy to be here.
All right, everybody have a great week, and we will talk to you next week.